Today we want to have a chat about one of the biggest misconceptions in insolvency law and administration. If my property is in my spouse's name, it's safe from my creditors. Hi guys, my name is Liam Bailey. I'm the managing partner of O'Brien Palmer. I am a trustee in bankruptcy and corporate liquidator. And this is Stipe Vuleta. Stipe is the managing partner of Chamberlains law firm. Stipe, thank you very much for joining us today. Why don't you tell us a bit about Chamberlains?
Yeah, well, look, thanks for having me, Liam. And Chamberlains have been around a long time, but effectively in its current form, Chamberlains started as a small firm in Canberra focusing on property. And over the last 5 to 6 years, we've grown into a national firm. And I guess my passion's restructuring. And as I always like to say, it's about helping people not pay people and helping people get paid.
Today we want to have a chat about one of the biggest misconceptions in insolvency law and administration. It's one that I hear all the time. And this is the idea that if my property is in my spouse's name, it's safe from my creditors.
Yeah, Liam, I mean, it's a great topic because you're right. It's something everybody gets wrong and we hear it all the time. And frankly, it's pretty concerning when you have a chat with someone, particularly as a lawyer assisting with restructuring, to hear how confident they are about their asset protection strategies when that's all they are.
Yeah, that's exactly right. So we hear it all the time. My accountant's told me to put my assets in this particular place and therefore you can't touch them or they're not in play. But it's just not the case, particularly when we get to the point of formal insolvency administration. So having you here today, fantastic. Could you tell us a little bit from a legal point of view why that's actually the case?
Yeah, well, Liam, I think it's interesting to think about in two ways. Firstly, in the context of who might be chasing me for money or who might have a claim. And then secondly, in the context of how I might actually be structured and how did an asset end up in my spouse's name and how was it funded. And so in the context of that first point, I think it's really important to consider formal personal insolvency like bankruptcy, right?
Yeah, absolutely. We have, when we're appointed as bankruptcy trustees, we have a duty to consider the bankrupt's claim on property of a relationship of which they are a part of. How does bankruptcy affect property rights for property jointly owned in a relationship?
Yeah, thanks, Liam. Look, it's pretty straightforward. With a few exceptions, when you become bankrupt, all of your property, again, with a few exceptions, becomes the property of your bankrupt estate, which is controlled by a trustee, so an independent person such as yourself, who's appointed to manage the affairs of the bankrupt estate and investigate what's going on. But what that effectively means is if you own property in your own name, that immediately becomes the property of your creditors in a way. And I think that where the misconception arises is that a lot of people think, well, it's not in my own name, so it must just not form part of my bankrupt estate. And if you stop there, that's true. But when you look at different types of law, the laws of equity, the laws that have developed over the last 200 or 300 years, as well as other statutory rights that bankruptcy trustees have to actually investigate the way in which transactions are done, how a property got into somebody's name, how it was funded, you very quickly start to realize that it's a lot more complicated than people think.
Yeah, exactly. So one of the analogies that I found very helpful often relates the type of rights that people have to property in their spouse's name and how that would play out in the context of a family law separation.
Yeah. I mean, look, as a restructuring lawyer, family law does scare me, but you are right. The power of the family court to make orders about third parties is incredibly broad, and we've seen cases over the last 15 years where they've made orders not just against spouses and ex-spouses, but against the ATO and against independent third-party creditors. So yeah, once you throw family law into the mix, you realize that, hey, what happens if I get separated during a bankruptcy? What happens when we start to determine, well, who's actually got an interest in what? And all of a sudden you've got a bankruptcy trustee saying, hey, well, I might have an interest in this property that you purport you never had an interest in.
Yeah, so when we're appointed as trustees in bankruptcy, we often have a look at how is it that that property was purchased and financed. Now, If the debtor has paid the money to acquire the property or has been paying the loans for the acquisition of the property, the fact that that property is in somebody else's name isn't going to sufficiently put it beyond being brought back into the estate. The debtor has an equitable claim on the property, and we need to pursue that claim for the benefit of your creditors.
Well, Liam, it's interesting you raised equity, because even I think once people start thinking about equity, they often, I guess, misunderstand the way in which it actually operates when you're trying to determine how these equitable interests arise in a property. And so it's something I actually spend a lot of time training other lawyers on, because we see this as an area where even lawyers and restructuring advisors are giving bad advice in this area. And if you're going to do like a quick snapshot, you've got different types of equities that arise. So you're going to have things like constructive trusts, where a court's going to look back at a relationship at the end of a relationship or at the end of a transaction having occurred and said, well, what happens if the ownership as recorded on title isn't fair? So a really common example of that is, like you said, you might have one spouse on title, but the other spouse or even a third party, a parent, has paid all of the deposit for a property. And there's no evidence to show that it wasn't a gift or anything like that. And a court might very easily say, well, yeah, you're on title, but actually your spouse paid for it, or your mum paid for it, your mum's bankrupt, your spouse is bankrupt. They should actually own that property, or at least have a substantial interest in it. And then you start looking at things like, well, who paid for the mortgage? Who paid for the interest on the mortgage? Who's on the loan? Who paid for the upkeep and maintenance of the property? Did you do any renovations? And then you start getting into different versions of equitable interests about how you add back investment in the property. Do they relate to the underlying equity in the property, or are they charged back dollar for dollar? And that's before you start even looking at things like the presumption of advancement.
So if you're watching this video, the link below will take you to a presentation with lots of the legal references and some really detailed information in this area, if it's an area that you're interested in. But for today, I thought it'd be interesting to have a look at how that actually plays out when we're appointed as trustees, and how it also influences the way liquidators seek settlement from directors for claims relating to breaches of duty or insolvent trading. Because when we're appointed as an insolvency administrator, trustee in bankruptcy or liquidator, it's important to note that our first duty is to the interests of creditors. And when these asset protection strategies are implemented, it's often designed to protect those assets from creditors in insolvency administration. So how do we deal with that once we're actually appointed? As I said, when we're trustees, we are required to have a look at who bought the property, who paid for the property, who maintained the property, and does the debtor have a right to pursue a claim on that property? But this is also relevant in liquidations, because when we are pursuing a claim for insolvent trading against a director, one of the big things that we look at is whether or not it is commercial to proceed to pursue that claim through litigation. One of the issues might have to be that to get a recovery might end up resulting in us having to take an action to bankrupt an individual, because when the individual is bankrupt, then the marital property can come into play. Taking that into account, it's important to think that when you're seeking settlement, ultimately if you are bankrupted to get at those assets could come into play if you are made bankrupt, so they need to be part of your considerations when seeking settlement with a liquidator.
So it's a really good point, Liam, and I think it's something people often forget. And also, if you're talking about corporate insolvencies, I think people sometimes overlook, well, what were my spending habits in the context of the actual company that becomes subject to a liquidation? Right? So what happens if you used funds directly from a company to buy a property? You might have an equitable claim on behalf of the liquidator against the property you bought. Or what happens if you funded improvements to your property using those funds in the company? So on top of the fact that you could be pursued all the way to bankruptcy and then chased around for many years to get access to the spouse's property itself, if you haven't been financially hygienic and you're not able to show with good certainty how you came to actually spend money, you could be a liquidator in very rare circumstances, could also have a claim directly against a house or a car or against another asset. So getting advice on how to properly administer your affairs is important, but also getting advice on, what your risks are so that you can, continue to comply with your obligations. Because I think, as a lawyer, one of the biggest challenges I see is so many people as directors enter into quite a contentious relationship with liquidator or bankruptcy trustee because of uncertainty, because of bad advice, forgetting that under statute, those people still have duties and obligations to do certain things. And maybe I'm just a genteel person, but if you've got good advice and you've got nothing to hide, then it means that you can actually fulfill those obligations without making life difficult for a liquidator or for yourself, keeping costs down and coming to a commercial resolution without too much stress.
So obviously the full range of issues surrounding protecting assets of a relationship are too broad for us to be able to canvass in today. But I guess the point is, get some advice from a qualified lawyer for the specifics of your circumstances and think commercially about these issues rather than obstructively for the best outcome, because a liquidator is always looking for the best possible outcome with the least amount of costs incurred to reach that point. And with that in mind, you can be empowered to achieve the best possible settlement for all stakeholders.
Yeah, I totally agree.
So, Stipe, quick plug for a Chamberlains before we go.
Oh yeah, chamberlains.com.au or find us on socials, and I hope to see everyone around on the internet sometime soon.
Mate, thank you very much for your time today, and I look forward to speaking to you all again soon. Thank you.
Oh, that was lovely. I've got no bloopers. Normally we smash bloopers, Liam.